Good afternoon, everybody. It's Katarina speaking. If you can hear me, may I ask to get a quick message in the chat? Yes, I see some replies. Just a quick message to make sure that everybody can hear me. You can find chat in the bottom right corner. Okay, well, apology for this. I hope you can hear me now. Okay, perfect. Thank you very much. Well, my name is Katarina. I would like to welcome you to today's webinar on behalf of the Child Health. I am very happy to see that we have 5 new people who are new to Child Health webinars, and 4 of you are new to webinars experience in general. So we are very happy to have you here. We hope you will like it, and we hope you stay tuned for the upcoming webinars on this particular topic that we will be hosting in March. Just a quick note before I give floor to Shona and then to the speaker that we have for today. Just a quick note for everybody. This session is being recorded, so the recording will be available after the webinar on our webinar page. For your colleagues who couldn't join online, you can share with them. Also, to make sure that you can hear us and the speaker, you should make sure that the speaker's icon is green. It's on the top black bar, and this one should be green throughout the whole session. Unfortunately, there is no microphone option for participants, so we count on you to write in the chat. Please feel free to use the chat and share your comments and questions. Today, we have a unique opportunity to hear a very interesting speaker, and you should use this chance to ask any questions you may have at this point on the topic. Thank you for answering polls. It's always interesting to see your replies. If you have any technical problems during the webinar, you can write to me in the chat, and I will do my best to help you. I would not prolong anymore. I can give floor to Shona. She is the Promise project manager.
Thank you so much, Katarina. And good afternoon, everyone. I am Shona von Blixen from the Council of the Baltic Sea States, and we are the lead partner of a project called Promise. And Promise is promoting the spread of the Barnahus model throughout Europe. The Barnahus, sometimes known as a child's house or a children's house, is not a place where children go to stay. Rather, it is a child-friendly office where law enforcement, criminal justice, child protection services, medical, mental health workers all cooperate under one roof, a child-friendly location. And they're cooperating to listen to the child's story and provide rapid access to justice and care for child victims and witnesses of violence. We're now in the second phase of this project. The first phase launched a European-level dialogue, which explored the criteria for Barnahus and similar models in depth and developed standard-setting publications. Select professionals from around Europe were invited to this process. Now, in the second phase, countries are developing their own national dialogue, agreements, capacity, and more. And with this webinar series, From Zero to Barnahus, it's an open invitation to join the discussions and take part in the learnings within the European Barnahus movement. These learnings include key principles, standards, and challenges to consider when opening and operating a multidisciplinary and interagency collaboration for child victims and witnesses of violence. And we're so glad that you all could join us here today. Now, Barnahus is an Icelandic innovation based on an American model called the Child Advocacy Center. There are distinct differences between the models, and one of the, for this call in particular, one of these is particularly important. In the US, children who tell their story at a child advocacy center usually still have to be present in court. Whereas in Iceland, their innovation was to integrate the Barnahus into the social and justice systems and enable that pre-recorded audiovisual testimony is admissible as evidence in court. This means that the child avoids having to repeat the statement at the courthouse, and the child also avoids potentially facing the accused in court. This, in fact, is a key common criteria of Barnahus that Promise is promoting, and that many Barnahus around Europe are already achieving. That a Barnahus ensures the evidentiary validity of the child's statement in line with the principles of due process, and is preventing the child from having to repeat his or her statement during court proceedings. Today we will hear the perspective from an Icelandic judge about this, but first I want to highlight two Barnahus quality standards that are relevant background for this call. The first is Barnahus quality standard number 6, the forensic interview. There's much more to read about this one, but I want to highlight in particular that the standard here is that forensic interviews are carried out by specialized staff at the Barnahus. These staff members are specialized in providing a child-friendly environment, adapting to the needs and abilities of the child, and eliciting the child's free narrative in as much detail as possible, and complying with the rules of evidence and the rights of the defense. Quality standard 1.3, avoiding undue delay, highlights another important role of the Barnahus, that when working as a multidisciplinary team with a streamlined process under one roof, the interview can be coordinated within certain time limits, and as few interviews as possible are needed. This means it's easier for the child to tell his or her story, to remember the details, and the quality and value of the testimony is ensured. And when the recording is valid as evidence in court proceedings, it means the child is able to start the healing process, rather than feel as if his or her life is on hold. You can read much more about this and more in the Barnahus Quality Standards publication from Promise. We have a short version, a long version, an ebook, many translations. See also our other publications at the link. Dear listeners, we hope you take this opportunity to ask all of your burning questions and also to talk with one another about this important topic in the chat. We'll be keeping track of the questions and comments. We'll pose them to the speaker at the end. We've planned plenty of time, so don't be shy. And now it's time to welcome our speaker for the day, Mr. Simon Sigvaldason. We're delighted to welcome you to kick off our webinar mini-series on the forensic interview in the Barnahus, and to share your perspective and experiences as a judge in Iceland working with this model. It's all yours.
Thank you so much, Joanna, and hi everyone. This is my first time doing a webinar. I learned that this is not a very complex mechanism, so I hope that this lecture will go well and we will not experience any technical problems. It's great to be with you, as I say, and being able to share with you some ideas and some visions that we have gone through when we have been doing our part of this process as a part of a criminal investigation in Iceland. And I've been so fortunate to stroll along, so to say, from the beginning. I remember very well when Barnahus was originally put through, and at that time I was working with the Ministry of Justice in Iceland and later the prosecution's office, and so I've been there from the start, and I have been following what has happened until today. So hopefully, if I'm not sharing with you everything that you want to know about, you are of course then able to ask me later on about some specific matters. But as you perhaps know, Barnahus was originally put in place in 1998. So we have a few years in practice, and I believe that those years have been used wisely, so to say, in many aspects. And today, Barnahus is of course a cornerstone in the Icelandic system, so to say. Of course, the judicial system as well as the other systems that have already been mentioned. I am the Chief Justice of the Reykjavik District Court in Iceland, and That's the absolutely biggest district court that we have in Iceland, and we have most of those cases that are pending in the criminal matters in Iceland. Now, there are mainly three topics that I want to share with you here today, and of course open for so much else as we continue. I will try to touch upon the issue why Barnahus is positive for the judicial process. I will also touch upon this subject on protecting the child, if Barnahus does that, and then towards the end I will speak a little bit about the due process and the rights of defense, and then towards the very end I will discuss some reforms that are already been discussed in Iceland, because this is of course an ongoing thing, the judicial process. I guess, I mean, we are always under the scrutiny of the courts of human rights, of course, and we have to adjust to their standards, and that is of course an ongoing project. So these are the main things that I will address here today in this not so long discussion that we have here today. In the very beginning, I would like to say this, the importance of an open mind. As I said, I have been with this project from the beginning, and even before this project started. I started my work after my graduation as a lawyer at the criminal court in Reykjavik back in 1989. And then I was working along with that this matter for the years after that, and this is not one thing that happens when you go through this process on how can you, at the same time as you are gathering the facts of a case, and you want to have the facts, we have to have the testimony of everyone, and at the same time you are trying to preserve some other goals, like doing as little harm as possible when you are dealing with these matters, and I think it's very important for everyone involved to remember that there is always, I mean, you have of course this is very much outlined in law, of course, but there is still always a room for improvement within the law. You can think about, can I use some different methods? Can I have a different approach, and so forth within the law that are already there, and this idea with Barnahus today is of course a long process where people involved just came together and thought, I mean, what can we do to improve these matters, and towards the end we have a much better system than we had before, and this is just a reminder that people should never take anything for granted. I mean, you should look at your system, how it works today, and just think by yourself, I mean, is there anything I can do to improve on these matters? I mean, the process, is there anything in the process that I can work on that improves this line of work, and I do believe that there's always something there that you can improve. And then of course the big picture is of course that if you want to just totally change the system and do a more radical improvement, then of course that is probably almost always up to the politicians and the Ministry of Justice and so forth. But as I say, everyone should should of course give this a great thought, no matter where you are within the system. And well, this is a very important thing, of course. We believe that Barnahus is a very positive thing in Iceland for the judicial process. Well, there are of course a few things there that you have to bear in mind. I mean, we are of course seeking the truth in every single case that we are both investigating and we are have hearings about in the courthouse. So we are always seeking the truth of a matter. And we believe that the best way to get the truth when you are doing an interview with a young child is to focus on the child itself. And you have very different individuals when you are looking at the child. I mean, they are of different age, they are of different, they develop differently and so forth. And you have to understand all of this by looking into the individual. And we focus on that. This process with Barnahus is very much focusing on that. Because when you have an interview in Barnahus, the experts that are conducting the interview, they are highly skilled and experienced and educated persons who know so much about child's development. They know that at a certain age you have to approach the questions in a certain manner, and that is very different from a very young person to a slightly older person. So this is a very fine line there, and for the person conducting the interview, it's a key factor that this person understands the child that is involved, its maturity, how it is developing. So approaching the questions to get the child to tell its story is extremely important to understand the child. So this process in Barnahus, where we have these experts, psychologists, there are very well-educated psychologists and with expertise on child development. We feel that these experts have just made it so this interview so much better and better performed than it was before, and therefore with this hearing in Barnahus, we believe that we are getting a much clearer story of what happened. So it's a very important factor for the judicial process, because we of course just want to find out the truth of the matter. So as I say, we have experts in early development of children conducting these interviews, but the process, of course, is in the sense that when the police believe that something has happened, somebody has turned to the police with a suspicion of something that has happened, or school authorities turn towards the police or whomever, then the process starts. And it starts in the sense that we are asked at the district court to conduct a hearing at Barnahus. So we summon everyone to the table, which is of course the prosecution, the police, the person that is suspected to have done something has his defense lawyer, and there is a lawyer for the victim, the supposed victim. So everyone joins at a table in Barnahus, and then we conduct this hearing. the specialist that is doing the hearing itself comes towards this table, and we have a short discussion on beforehand on how we are going to approach this interview, and then the person conducting the interview goes away and has this interview with the child in a different room, and the others watch the interview through a monitor, and the judge who is conducting the interview in that sense has a microphone, so he can just speak to the person who is conducting the interview through a speaker in his ear. So then the interview is simply is taking place, and everyone is watching at the same time. So normally, after the interview has been done, or the person that is conducting the interview is finished, then we have a brief session afterwards where we discuss, is there anything we should simply focus more on, so we should continue the interview, or if this is good for the time being. So in that sense, we try to make it sure that everything of importance is documented in this very interview, because our goal is not to have to repeat it, and of course the goal is that this interview will then be used later on in the process, if the case goes before the court, then this interview is the key factor in the process of the matter later at the courthouse. So this is of course extremely important for the process of the case. We want to know the real facts. We want to have these facts in circumstances where there's a very skilled person conducting the hearing, and we want to have anyone involved, these other actors in this thing, prosecution and defense and everyone, to be able to come to the table in the sense that they can point out if there's anything lacking from the interview. So this process is we feel that this process is doing its purpose in a very positive manner. Then of course the other angle of this matter is, of course, what about the child itself? I can tell you that when Barnahus started this process, we at the same time had some other facilities in the judicial system that was supposed to be applied in the same matter. At the courthouse in Reykjavik, we had a special room where we could conduct a hearing there in a very child-friendly environment, but it was in the courthouse, and imagine that scenario where you have to go through a courthouse with all its functions, all these cases that are pending. You have to walk with the child to a certain room and where you conduct the hearing, as opposed to Barnahus, which is situated in the suburbs of Reykjavik, where the child comes to this house just like it's coming to any other regular house. I mean, the child is much more relaxed. By going through a courthouse or a police station, you already have built up some tension, and it's much more likely that the child will suffer some trauma or some serious things by going through that part of the process. So this thing of conducting this hearing outside of this thing that we call a courthouse or a police station is a very important factor. Children come from all over Iceland to Barnahus. They fly out from from the west, north, wherever, and they simply go straight to this house in the suburbs. So I have often conducted a hearing of this matter, and you can sense that the child is coming into the interview so much more relaxed than it would be otherwise. So for the child itself, I think this process is very, very beneficial. And we, of course, want to do as little harm as possible to the child, and we believe that this is very much benefiting that purpose. Almost from the beginning, we have, of course, had questions of the due process in this matter. Cases that have been brought before the court there have been many cases that have been going through the system where defense lawyers have challenged this process, and mainly, of course, because of the fact that in these circumstances the child does not itself appear before the court. And according to the Convention of Human Rights, the defense, of course, has the right to ask questions towards witnesses, and so this is a very crucial factor, of course. Is it possible to conduct this hearing and do this process on these terms and not be violating the Convention of Human Rights? And the Icelandic Supreme Court has ruled many times upon this, and they have agreed that this is in accordance with the Convention of Human Rights and the Constitution of Iceland, which reflects the Convention, of course, because we have the Convention of Human Rights is, of course, a part of the Icelandic law. So the Icelandic Supreme Court has many times ruled upon that this does not contradict the Icelandic Constitution, and the Court of Human Rights actually has done so too in this case that I cite here from 1996. That's of course in this beginning phase of Barnahus and all this process. And of course, the important factor in all of this is this aspect. Does the defense have the opportunity to ask questions if this is something that is lacking from the interview? And in this ruling of the Court of Human Rights, I mean, it was stated that this process that we use here is open for this. That is to say that the defense has always this opportunity to put forward questions, ask for something else to be extra being asked. So in that manner, the defense has the right to ask questions or put questions forward. And on the other hand, that's also the thing within the Icelandic procedural law. I mean, although we have the Barnahus hearing conducted, there is, of course, still this paragraph in Icelandic procedural law that says that when the case then comes before the court, and if the prosecution or the defense ask for something extra being asked, then it's possible to do so. And it's of course upon the based upon that the judge grants this permission, and of course it has to be something of extreme importance for the case if there is an extra hearing to be conducted, because the goal of course is to do this only once, so that the child does not have to go through repeated asking and has to review its testimony or the story and repeat it again and again. So that's the main purpose, of course, of all this process. So the courts of human rights have, so to say, blessed this process that we have in Barnahus today. So, and they say that it's not in violating the rights of the defense. We are today undergoing some critical thinking, of course, in all this process, as of course we should and everybody should be doing. And now we have a fairly similar judicial system within the Scandinavian countries. And we compare, of course, our systems quite a lot, and we try to gain some information and some expertise knowledge from other countries. And I can say, for example, that in Norway they have been undergoing some changes there as goes for this process. And it's a thing that I myself have sometimes been asking myself, and as the process is today, as I described before, the hearing in Barnahus is a part of the judicial process. It's a part of a court hearing because there's a judge supervising the hearing. This interview is in the very early phase of the case itself, because there are some alarms, and people think that something might have happened, and that's the first step of the case, to go to Barnahus and have this hearing. So this is, of course, is the first overall hearing in the case. Everything is left, among others, the hearing of the accused person, or the person who is suspected to have committed something wrong. So that hearing is still left. So this process, of course, then is different from regular proceedings in Iceland, where it is normally so that if there's a charge in a matter being put forward, or police starts its own investigation, the first hearing is of the person who is supposed to have committed something wrong. After that, when we have the testimony of that person involved, all the witnesses are being heard. This process in Barnahus is reversed in the sense that first we have the victim, and then we have the person, hearing of the person who is possibly doing something wrong. And that person then can adjust its testimony to the testimony of the victim. And that is, of course, not that is coming from another angle that we have normally in Icelandic procedural law. So, and then there is another thing that is being discussed, and that is the thing of this process. Does it have to be a process before the court at that stage? Is it possible that this is simply a police, on a police level, that this hearing is being conducted by the prosecution, by the police, instead of having it on a judicial level? That is a question that we are going through at the moment. If we should not involve the court at this level and have it simply at the level of the police, and if that, and at the same time, there is a question whether the defense lawyer should be present at that same time. And this is, of course, so that the person that is being suspected of a criminal behavior does not have the testimony of the child before he gives his own testimony. And I believe that in Norway they have made some reforms in that direction, and this is being discussed in Iceland at the moment too. So it is not unlikely that this might be the thing, that we would alter this a little bit, but still, of course, the whole purpose of Barnahus and that process is still very much intact, I would say. So this was the main things that I wanted to share with you here today, and I hope I have shed some light upon Barnahus and how it's being used here in Iceland. And of course, there's so much information out there, as was already mentioned by Joanna. But I, of course, then is open for questions, and I hope I can answer them as they come in.
Thank you so much, Simon. I want to start off by thanking you first for encouraging our listeners to find ways within their current systems to do what it is that they can. It's an important message, and I think one that our listeners take to heart. And actually, the next slide here is of the hearing room, which you discussed. So I thought I'd share that while we continue. It was also really important to hear about your experience of the difference between the child-friendly room at the courthouse versus using the Barnahus, and how the Barnahus is a much more relaxing atmosphere and conducive to the child telling his or her story. There's a number of countries right now that are still deciding how to prioritize their resources in this regard. So it's really, really important for us to hear about that experience. And also very interesting to learn about this discussion about the interview possibly being at the police prosecutor level in the future rather than at the judicial level. And I think a lot of our countries are looking to launch more on that level. So I'm keeping an eye out for questions in the chat, and I'd like to encourage you all to write some questions, but I have many questions to get us started. And firstly, was there a specific case that you remember? I know it was 20 years ago, but was there a specific case that you remember that convinced you that the Barnahus approach was the way to do it? Can you tell us a story in general terms about this?
Well, of course, this is so long time ago, but I remember being a part of this process in the early stage where before Barnahus was there, where we had already tried out this filming of a child's testimony, done by experts, but they were then often somehow linked to the social affair system, working with children, and we sometimes, and they perhaps they were very skilled persons, and we sometimes got them to come and conduct a hearing in a child-friendly zone, and it was being filmed. I remember that, and that was not in the courthouse, but it was not in Barnahus, and I remember a case of that sort that I tried out myself when I was at my early years as a judge, and that was a case that occurred up on west of Iceland, and that case went through the lower court and the Supreme Court, where the Supreme Court upheld my conviction, and that was that's a preface, but I think that I can generally say that, of course, one of the persons that was so influential on all of this was, of course, Bragi, who was the somewhat a founder of Barnahus. I mean, he was very good in promoting this idea. He did a very good job on that, on promoting the idea, and he was very fortunate by having all the skilled staff with him in the early phase. So it was so important that the first steps would not go wrong. And I think that they did a wonderful thing at that time. But these systems were in a way working a little bit parallel in the early years, because this interview room that we had at the courthouse in Reykjavik was being used parallel to Barnahus in the beginning phase. It was a bit criticized. It was criticized a lot. I mean, the relatives of the victims, they were not pleased having to go down there to the courthouse where they knew that they could go to Barnahus. So these were some years that were difficult in many ways. But we had these two systems running parallel in the beginning, and of course there were some minor things both with Barnahus and also with the courthouse that the Supreme Court could find to criticize. But the broad picture is that these experts that were working in Barnahus in the early phase, in the early years, they were doing such a wonderful thing, and they were so professional that this more or less was a success from beginning.
Well, that's amazing. Olivia Lynn Halderson, the author of the Barnahus Quality Standards, asks if you could say a couple words about the process and the procedure and protocol in this observation room that we have on our screen right now, including your role.
Yeah. So what we see on the screen, of course, as you mentioned, is the room in Barnahus where all those gathered that are part of this process. So with the microphone towards the end, there's the seat of the judge, and this is the microphone that he uses if he wants to give some message to the person who is conducting the interview. On his right-hand side would normally sit the prosecutor, and beside the prosecutor would normally be a police officer who would be conducting the police investigation. And on the judge's left-hand side would be the defense lawyer, and typically on his side would be the lawyer for the victim. And then we would also have present someone from the Child Authority Office in Iceland, Child Welfare System, and then there would be one person extra who would be conducting the tape, starting the tape and stopping when the hearing would be over. Yeah, so that would normally be the thing.
And then a bit about your role, and then we have another question from Jen Kolender, who asks about the interaction of the suspect in the observation room. I guess that would be the suspect lawyer, or.
Sorry, could you repeat that?
Jen Kolender asks to hear more about the suspect or the alleged parties' interaction in the observation room. So I guess the question is does the suspect have a lawyer in the observation room, and what's the interaction? How does that work? And also a little bit more about your role and like how are you in charge?
So the person that is suspected at this very moment has his defense lawyer, and that person, as I said, is sitting on my left-hand side. So the suspected person has his lawyer present at the hearing. And as I said earlier, one of the ideas about the reform is that might be excluded in the coming years in this hearing, but let's not go into that right now. So the defense or the suspected person has his lawyer present at the hearing. As I say, I sit at the end. Of course, the person suspected is not itself never present. That never happens. So I sit at the very end, and as I said earlier, before the hearing starts, we have a brief session at the table with the person conducting the interview on what we wanna focus in the interview ahead. If there's anything we would like to emphasize, if there's anything we should really concern us with, and that's often related to the age of the child, or if the child has some certain handicaps or something like that, just so that the person conducting the interview, of course, is very much involved in this at this point in time, because that person is the expert, and he or her tells us how she wants to approach the questions, and asks us if we have any objections towards that. And so there's a consensus then there before the interview starts on how to approach the interview, how we want to get the truth, how we want the child to tell the story, and what in which how much we can get the child to how we can so to say influence the child of just coming out and telling, because this is also a very delicate thing, because we don't want the child to experience that they have to tell something, or that they have to comply with the person asking the questions. This is we never want the child to tell something that has not happened. So we may not encourage the child too much. We have to be very delicate on this matter. So this is a brief discussion before we start. And as I say, then the interview starts, and we sit there and listen. The judge normally has a pen and paper in front of him, and if there are some questions that arise and enter the interview, they put it towards me and say, we think that this is a bit unclear. Can you ask her to be more specific about this matter? And I have these questions on my table then, and I am the one who decides if this question should be put through to the conductor of the interview. And if I feel that this is a question that is advisable and it should be asked, then I press the button and say to the person conducting the interview, we think you should ask a bit more specific about this certain matter here. So that is how it is. I am the only one being able to speak to the person conducting the interview, and I decide what questions are allowed and who's not. And they, of course, can ask for, they put forward their preferences, and I am the one putting it then along.
Perfect. Thank you so much. Another one of our colleagues, Rebecca O'Donnell, she would like to know if the same judge is involved in the interview and in hearing the case, and if the video recorded testimony is actually shown in court, and if so, is that ever edited or is it shown in whole?
So according to our procedural law, it is preferred that the person who's conducting the interview then sits on the case later on. It is preferred, but the paragraph is very open. So and it has happened many times that that's not the case. That there's a different person than conducting the or processing this case at the courthouse, and it has never been criticized or there's not, the Supreme Court has never done anything serious about it. So although it's but of course it's preferred. It's probably benefiting the case, but it's not always possible. Then the other thing is that when this case comes to the court, this interview is on a dish, and the judge can watch it at his chamber as much as he wants. And usually it has been, and there's a transcript of the testimony, of course, within documents of the case. So both the prosecution and the defense, they have a the testimony is in full within the documents. They can then, under the hearing, ask the court this part to be played within the courtroom. They can say, we want this specific part of the hearing to be played for everyone to see. So that is simply up to the session at the courthouse, if there's anything to be played there, and if so, which part. And normally it is not the whole interview. It's very unlikely that the whole interview will be played out in the court.
Our colleagues from Hungary wonder if every judge in Iceland goes to the Barnahus to hear sexual abuse cases, or is it so that every judge in Iceland will receive such cases in their courtroom? It's
very likely that every judge in Iceland has been conducting a hearing Barnahus, and as I say, the courthouse, the district court in Reykjavik has 25 judges, and we have just a roll there, so that we go from just simply by the alphabet. So we take the judges as by the alphabet. So every single judge at the courthouse in Reykjavik has to go there at some point. And for the other district courts around Iceland, they have from the district court in Reykjanes, who has 8 judges, but others have from 3 to 1. And so it's very, very likely, and I think it's almost guaranteed that every single judge has at some point been there.
Just looking through the many questions coming in. We have some questions about the suspect. Someone asked for clarification about how much information the suspect gets before their interview.
Well, I think I can answer that very briefly. I mean, before the interview, there's very little known, because before the interview, it might be that a school points out to the police or child authorities that they suspect something to have happened. But I know that from all these other angles, I mean, if it's the school, if it's the social welfare or wherever, it's always been extremely important that if there's a suspicion, that these parts don't go into questioning the child, because the first story of the child, the first real story of from the child, has to be within Barnahus, because we don't know in what setting the other interview, so to say, would be conducted, if it's at the school or at the child welfare office or whatever. So we have stressed it such a lot towards schools and social authorities and others, that if there is a suspicion, don't do anything about it. Just put through a message that you have some information that should be checked upon, and then so the first real story comes there at Barnahus. That's the first time we hear the whole story.
We will be wrapping up in just a moment, but I want to have 2 more questions. One's a quick one, and one's maybe a little bit of a longer one. One from Hungary. In Hungary, the police writes the protocol at the time of the interview. When does this happen, the protocol happen in Iceland? And then the longer question is, we have many listeners throughout Europe right now who are working tirelessly to get judges on board with the Barnahus model so that they can meet the Barnahus quality standards in their own countries. If you have any advice, words of wisdom, how to reach this target group, and what do they need to hear?
If I start with the second question, I have on previous occasion been giving a speech about Barnahus in a forum where there were judges, prosecutors, and others, and I understand that this is a bit of a challenge, so to say. Judges tend to be very conservative. I mean, that's a part of the role as a judge, to be very conservative, to be very critical. And the judicial system in each and every country, they are so extremely different. It's amazing. I mean, you have international law on so many different matters, and you are trying to get a similar system throughout the countries for this and that, if it's the banking sector or whatever it is. But when it comes to the judicial system, it's always so extremely unique for every individual country. And the process there, it's so different. So of course the judges tend to be very skeptic when you want to totally review and renew the process, because the process is so old and has always been just handed in stone. So I feel that so they need to hear it from another judge, so to say. I don't like formal clubs or anything like that, but they often need to hear it from another judge who is sitting in the same seat as they are. So if you want to convince the judges, I would think it's very beneficial to have another judge telling them their story.
And this is why we're so happy that you were able to give us this wonderful webinar today. Thank you so much to everyone who asked so many brilliant questions in the comments. Please email me if we did not get to your question, and we will absolutely get you your answers. Mr. Simon Sigvaldason, thank you. This will be rewatched and rewatched many times over, and we're so honored to have had you with us today. I think I should now hand it over to Katarina to have the final word. Yes, there she is.
Thank you very much. Well, also from my side, first of all, many thanks to a very interesting presentation. And despite, as an outside Barnahus person, despite I thought I learned a lot through the past months of Barnahus presentations, today was really interesting for me as well. And many thanks to everybody for joining us today and for asking questions. It's always nice to see that you have many questions, because this is the way we start discussing. I hope this webinar was useful for you. And as you could see on our screen, we will have the two upcoming webinars in this series. Maybe I can arrange so that you can see them. March 7th with a start at 2 p.m. at the same time as today, and March 14th. We hope to see you there, and many thanks for the presentation and to everybody for joining us today. If you would like to receive a certificate of attendance, I will write an email in the chat, and you can just write to us quickly there asking for the certificate. Many thanks to all, and have a good day, everybody. Goodbye.
Ciao.